Jurisprudence and Legal Theory, Lecture 10, Liability, Meaning and the Definition of Liability and Different Kinds of Liability is the topic for discussion today. Dear student friends, you are aware that I am Dr. Rekha Surya Rao, Senior Professor of Law and Principal Retired, and author of more than 30 textbooks of law, of which 25 subjects have been translated into Hindi and other academic assignments. Before going to take up the lecture, let me take 1 minute to pay homage to my reverend parents, late Ragappa Rao and late Srimati Kantaratnam, and my beloved wife, Mrs. Balivata T. Gauri, associate author of all my academic assignments. And let me express my deep sense of gratitude to all my student friends who are instrumental for what I am now. And finally, I express my gratitude to the author of various textbooks, research papers and articles whose works I am making use of for delivering this lecture and all my academic assignments. Dear friends, now topic for discussion is liability, meaning, definition and different kinds of liability. As per syllabus, there is a main liability, meaning, definition, civil liability and remedial liability, criminal liability and penal liability, vicarious liability, state liability, strict liability, absolute liability, government liability and no fault liability are to be discussed. But before going to discuss as per the scheme, let me let you know what are the various kinds of liabilities and what is the variation or difference between one liability to another first, and will take up and will enlighten you as per the syllabus. Now, liability is an obligation or duty created by law. Sometimes it is suo motu, it is created by law. This liability is created by suo motu out of an agreement. It is created by law or principle of equity, that is dharma. There are different sources. The reason for creation of liability is commission of a wrong. Wrong is commission of an act which you are not supposed to commit or which you ought not to commit. Wrong takes place if you omit to do an act. So, wrong takes place in two ways. One is commission and other is omission. If you commit an act which you should not commit or which you ought not to commit, that is wrong. So, negligent operation, negligent accident, etc. It is commission. Omission in the sense an act which you have omitted to do, though you are supposed to do, means an act which is not committed, which you ought to do. So, if you do an act which you should not do, which you don't do an act which you should do, results in wrong. So, commission and omission. Commission in the sense negligent operation by doctor results in wrong of negligence. Nurses, medical attendants, omission to give oxygen or injection in time to patient, resulting in the death of patient, is omission. Sometimes killing a person by giving poisonous food or killing a person by omitting to give food by locking in a room, both are wrong. Sometimes commission results in wrong, sometimes omission results in wrong. If the wrong is of less serious nature, it is a civil wrong. If the wrong serious nature, it is a criminal wrong, crime or public wrong or offense. So, when a wrong is committed, this wrong is committed either by breach of duty created by law. This wrong is in law of torts. Breach of example law of torts. If a wrong is committed by breach of an obligation from an agreement, if a breach of contract is example. Sometimes the wrong is committed by violating the principle of natural justice. Example, quasi contract. Because suppose finder of lost goods is best example. If you find some purse containing some cash, it is your duty to give it to somebody. Otherwise, it amounts to wrong if the right owner can bring an action against you. So, this is what. So, ultimately, wrong is the basis for emergence of any duty or obligation. That obligation refers to liability. This liability is of various kinds. If I commit a wrong, this wrong, if it is a serious wrong, and it is a public wrong or crime. If it is simple wrong, it is a tort. If a wrong causes injury to one individual or group of individuals, it is private wrong. If the wrong causes injury to the society as a whole or public at large, it is public wrong. Public wrong is also known as crime. It is also known as an offense. So here the word offense is used in Indian Penal Code, Criminal Procedure Code and all special legislations relating to criminal law. So now we have to discuss about when the private wrongs, all private wrongs, namely breach of contract, breach of quasi-contractual obligation, tort and many other wrongs are tried in civil courts. That is why they are called civil wrongs. But other than the civil wrongs, if a wrong causes injury to society at large or public at large or state as a whole, that wrong is a public wrong or crime or an offense. The word offense is used in all criminal law legislations. So, if private wrongs are tried less in nature, they are tried in private civil courts, they are called civil wrong. All public wrongs or crimes or offences are tried in criminal courts. So, the cases tried in civil courts are called civil proceeding. The cases tried in criminal courts are tried in criminal proceeding. So, this is that is why this wrong creates liability. This liability is out of an obligation or duty. This liability is created out of an obligation or duty. This duty or obligation is corresponds to right as enunciated by Solomon. Now coming to the point, there are various kinds of liabilities. We have to know the difference between different kinds of liability. Suppose I commit a wrong, I alone is liable. My liability is called individual liability, independent liability. My liability is independent or personal. I alone is liable. If I have breached the contract, the other party can file a case against me. So no other can. Suppose if I violate a law if I violate a duty created by law, I alone is liable. Suppose of traffic rules. If I violate traffic rules, I alone is liable. So the person who has committed a wrong, it may be a civil wrong or criminal wrong, he alone is liable. That liability is called independent liability. If one person commits wrong, joining, if a person commits wrong and two or others join him, that liability is joint liability. For example, A is going to B's house for committing murder or committing theft. Suppose B and join him to accompany him in that theft or murder. Three of them are joint wrongdoers. The liability is a joint liability. If it is civil wrong, the liability is joint and several. If it is a criminal wrong, the liability is joint and constructive. What is joint and several refers to civil proceeding. Joint and constructive refers to criminal proceedings. For example, A, B and C jointly borrowed 3 lakhs. A, B and C jointly borrowed 3 lakhs from D against a promissory note. And in the event of default, the D can file a case against three of them. If a suit is filed against 3 of them, A, B and C are equally liable. That liability is called joint liability. If the amount they shared these 3 lakhs, 1 lakh each or 50,000, 1 lakh, 1.5 lakhs, or whatever may be the proportion of utility, it is different. But whether received more or whether received less is not. But 3 are equally liable. They are proportionate. If case is filed, A, B and C should meet the liability at the rate of 10,000 rupees, 1 lakh rupees each. Even though A enjoyed 50,000, B enjoyed 1 lakh, 3 enjoyed 1.5 lakhs. If suit is filed by D against A, B and C, this liability is called joint liability. Suppose in civil proceeding, the liability is also called several. Suppose A, B and C, A used only 50,000, but A is financially sound. D chooses only A to file a case. So D files a case against A, who used only 50,000, who enjoyed only 50,000, remaining 2.5 lakhs by B and C. But A alone is liable to pay 3 lakh rupees. He cannot say that I enjoyed only 50,000, remaining 2.5 lakhs availed by B and C. You go and ask. He cannot say. So, if A, B and C jointly borrowed money from D, if D chooses one person, one alone is liable. Chooses 2 persons and file case, two of them is liable. He files a case against 3 of them, 3 are equally liable. So, if only one is sued, that liability is called several liability. If 2 or more jointly sued, that is called joint liability. So, this case is different in case of criminal liability, criminal law. Suppose A, B and C went to D's house to kill him. A stood outside. B tied his legs and hands, and C killed him with knife. So, the degree of the maximum principal wrongdoer is C, who alone taking knife and killed. B tied hands and legs, and C, A was watching outside. But still, when A, B and C are caught, equally they are given equal punishment. If it is life imprisonment or death sentence, as per section 302 IPC, suppose life imprisonment is given, A, B and C are A, B and C, their liability is called joint liability, which is studied under section 34 of the Indian Penal Code and if punishment is given, equal punishment is given to all. There is no any proportionate punishment. This is called joint liability. Next one is vicarious liability. Vicarious liability in the sense, one person commits wrong, another person is made liable. Another person is made liable. Lorry driver commits accident, lorry owner is liable. That is called vicarious liability. So here a principal agent commits wrong, principal is liable. Partner commits wrong, firm is liable. Direct commits wrong, company is liable. Like that, one person is commits wrong, another person is made liable. That liability is called vicarious liability. I have given very big lecture on vicarious liability in law of torts. You can verify for your information. So the instances of vicarious liability are master and servant, employer, independent contractor, firm and partners, principal and agents, company and directors. So government liability. Next, vicarious. If government servant commits wrong, government is liable. In olden days, government was not liable on the ground of sovereign, on the ground of sovereign immunity. So here in olden days, if government commits any wrong, government was not liable on the ground that king can do no wrong. King can do wrong. In olden days, king was the ruler. Today, government is the ruler. Government headed by prime minister in some countries, government headed by president in some countries, or the rulers are sovereign. So today, the government also is engaged in so many commercial activities. Government is liable like ordinary person. Ordinary person, the government is liable for the torts committed by the servants in discharge while discharging their duties. Similarly, the government is liable for breach of contracts entered into by the servants. Article 298 and 299 of Indian Constitution makes provision that governments can carry on business. Governments can do commercial activities. The commercial activities of the government are done by government servants. If the government servants commit any breach of duty, the government is held liable. Similarly, if government servant commits any tort, he commits any accident and he commits any negligent act causing injury or loss to another, for torts committed by servants in discharge of their duties and obligations imposed on them by law, the government is liable. But in olden days, government was not liable on the ground of sovereign immunity. But our king, government or king was not liable. But in England, Crown Proceedings Act 1947 was passed. The king or crown is liable like any other individual. In India also, development provisions are provided for under Indian Constitution. The government also is held liable for torts committed by the servants or breach of contracts committed by the servant. That liability of the government for torts committed by servants or crimes committed by the torts committed by the servant or breach of contracts committed by the servant, that liability of government for torts and breach of contracts committed by the servant is called government liability or state liability. However, there are certain exceptions to governors, ambassadors, governors, ambassadors, diplomatic envoys, President of India. They are exempted from liability because they are given sovereign immunity. They are not answerable in the courts of law. So this is with reference to state vicarious liability and state liability. If servant commits wrong, master is liable. If employer independent contractor commits wrong, employer independent agent commits wrong, agent commits wrong, principal is liable. This is what is called different kinds of vicarious liability. I have given independent lecture on vicarious liability and government liability in law of torts lecture. You can refer, dear friends. Next one is vicarious liability in criminal law. Vicarious liability in criminal law. Vicarious liability is the master is liable. Master employee is liable for civil liability only. Master is not liable for the crime committed by the servant. So that is why it is said that vicarious liability is unknown to criminal law. Suppose lorry driver commits an accident killing one or two persons, the master, owner of the lorry, is liable to pay compensation to the deceased. But that criminal liability, the driver will face the criminal liability. So master is liable doesn't mean that servant is not liable. Servant also is liable. Servant also is liable for civil liability. Master will take care of it. Criminal liability, servants will attend that because servant cannot do it. Respondent superior on the ground of respondent superior. All these things I explained in detail in vicarious liability chapter. So vicarious liability too is unknown to criminal law. Similarly, suppose you gave clothes to tailor for stitching. If the boy who stitches buttons and simple patchworks has stolen the suit and run away, the owner of the tailoring shop is liable to pay compensation. He has to pay the value of the suit, but he is not liable for imprisonment up to 3,000 up to 3 years imprisonment. If that theft, the servant who has stolen the suit is found, is liable for punishment up to 3 years on the ground of theft. So, like vicarious liability is known to criminal law. But still there are certain exceptions. There are certain exceptions to the rule. Abatement is there. Abatement by instigation, abatement by criminal conspiracy, abatement by intentional aiding. This abatement we study from article section 107 to section 107 to 120 I think. I will tell you the section later. Section 107 to 120 of Indian Penal Code lay down various provisions relating to abatement. So next one is this topic abatement. I have given detailed lecture in criminal law IPC. You can refer this friends. Next strict liability. Vicarious liability is unknown to criminal law, but if it is abatement, the master also is liable. If it is the case of occupiers liability, unlawful assembly rights, etc., the owner is liable. There are different cases. If the master has consented to it, the owner is liable. If a servant commits the crime with the consent of master, the master also will be liable. This is with reference to vicarious liability in criminal law. Next one is strict liability. Strict liability was created for the first time in Rallens versus Fletcher case, in 1860. So what happened in this case was, generally this is tortuous liability. I have given very big lecture on strict liability, law of torts. You can see here, friend. If the wrongdoer, if a wrong is committed by a person, if there is negligence on the part of wrongdoer, the wrongdoer is liable. If there is no negligence on the part of wrongdoer, the wrongdoer is not liable. For example, while driving the vehicle, suddenly brakes failure, wheels dislodged from the axle, suddenly when he is driving, suddenly a person crosses the road. Within a couple of seconds he crosses the road. Then that is inevitable accident. There is no any negligence on the part of this. Suppose if negligence is there in an accident, the wrongdoer is liable. If the negligence is not there, there is no liability. So whether a wrongdoer is liable or not depends upon existence of negligence. If negligence is available, he is liable. If negligence is not there, he is not liable. So that is the rule. But for the first time in the year 1860, Justice Blackburn of England coined a new rule, that is strict liability. There are certain circumstances in which the defendant is liable, whether there is negligence or not. Even though if there is negligence or there is no negligence, still he is liable. The type of liability is called strict liability. In this particular case, in strict liability, the plaintiff has taken all precautions. He is no way negligent, but still wrong takes place. But the defendant is put to liability in Rallens versus Fletcher. You can refer my lecture on strict liability for detailed information. So if the defendant is negligent or not, defendant is liable. That liability is called strict liability. However, in strict liability, 5 exceptions are given. There are 5 act of God, plaintiff's own fault, malicious act of stranger, statutory authority, like this. Some exceptions are there. Though there is no negligence on the part of defendant is liable, but defendant can escape from liability on 5 grounds. So exceptions are there. That is strict liability. So if exceptions are deleted, there is no exception, the defendant is absolutely liable. That liability is called absolute liability. This was coined by Chief Justice P.N. Bhagwati in the year 1986 in MC Mehta vs. Union of India. In strict liability, defenses are available. In absolute liability, defenses are not liable. Liability irrespective of negligence, with or without liability, with or without negligence is strict liability. That is liability irrespective of negligence is strict liability with it has defenses. Liability irrespective of negligence, there are no without any defenses, is absolute liability. Strict liability was coined in Rallins vs. Fletcher in 1860. Absolute liability was coined by Chief Justice P.N. Bhagati in 1886 in MC Mehta vs. Union of India. That is absolute liability. Next one is, last one is no fault liability. This no fault liability emerges from contributor negligence. The contributor negligence emerges from voluntary non-fit injury or assumption of risk, no fault liability. So here the voluntary non-fit injury the assumption of risk. Suppose when my friends are going to climb a hill, but I joined them. They warned me, but still no, I will come. I fell down and injured, leg is broken. But for my own fault, I cannot accuse them. I cannot claim any liability from them. This is what is called voluntary non-fit injury or assumption of risk. From this contributor negligence was developed. Contributor negligence in the sense, if wrongdoer is 100% negligent, 100% liability is there. 100% liability. If there is rash and negligent driving, there is a 100% negligence on the part of wrongdoer or defendant. If a case is filed, compensation is 10 lakhs, he should pay 10 lakhs. Suppose he contributed negligence. So the aggrieved party is 50, victim is 50% responsible. He suddenly crossed the road. 50%. For 10 lakhs, he is the wrongdoer is will pay 5 lakhs. Suppose the aggrieved is 100% liable. Suppose he intentionally fell into he intentionally fell into the back wheel of the vehicle, and then there is no any liability. For example, the driver of the vehicle has parked the vehicle on the road and the extreme left side, but somebody going on the road, some scooterist, dashed it and crushed into that vehicle and died. So here the parking vehicle owner has no liability, has no negligence, but still liability is created. That liability is created for the first time in 1980. That is what is called no fault liability. So this no fault liability was created by amending Motor Vehicle Act. Subsequently, Motor Vehicle Act was recodified in the year 1988. Subsequently, Motor Vehicle Amendment Act was passed in the year 2019. These are the various issues, various issues relating to various liabilities, dear friend. Now I wish to take up topic wise. I take up topic wise. Whatever topics I have given, I will exclude it. Now, firstly, liability meaning, definition and kinds. What is civil liability, what is criminal liability, what is theory of remedial liability, what is theory of penal liability, vicarious liability, state liability, strict liability, etc. We have to take up as far as possible. Now, meaning. So, the meaning of liability is the result. Meaning. When a person has committed a wrong, he or she is said to be liable for consequences of his or her wrong. When I commit a wrong, whatever consequences follows, I am liable. When one person, boy or man or woman, commits a wrong, some adverse consequences will follow. For adverse consequences are to be met by or answerable by the wrongdoer. That he is answerable in the sense he is liable. That that is what is called liability of that wrongdoer. Liability is the result of violation of violation of liability is the result of violation of law. While liability is the result of violation of law, violation of an agreement, agreements, terms under the contract, violation of the principles of natural justice, that is quasi contract, etc. So simply liability arises from breach of duty created by law, that is lot of torts, breach of rules and regulations formulated by the state, that is wrong. Suppose government imposes 144 section or curfew. If anybody breaches it, he is liable for imprisonment. He is liable. Suppose he finds some bag containing valuables. He cannot take it to home. He should hand out to the right person. That is breach of. So breach of duty out of agreement, breach of duty created by law, breach of duty formulated by the principles of natural justice, breach of duty violated by violating the rules and regulations framed by the state for public conduct. So these are the things. Now definition. It is very difficult to define the term liability, define the concept of liability, but however Salmond defined liability, and Markby also defined liability. There are several, but I want to give you two definitions. Salmond defined liability as vinculum juris. Salmond defined liability as vinculum juris. That means a bond of necessity and remedy of the wrong. Bond of necessity and remedy of wrong. Bond of necessity and the remedy of wrong. So it is a bond that lies between wrong and remedy. Whoever commits wrong is liable to pay the remedy to the aggrieved party. So according to Salmond, basing on this principle, Salmond defined liability in his book Jurisprudence, 12th edition, page number 349, as the bond of necessity that exists between the wrong and the remedy of the wrong. So Markby defined accordingly. According to Markby, the word liability is used to describe the condition of a person who has the duty to perform, whether the duty is a primary one or secondary or sanctioning one. So it also denotes breach of duty. It may be primary duty or secondary duty or sanctioning one. Primary duty means teachers' duty to teach in the class is primary duty. Bankers' duty to accept deposits and pay loans is primary duty. And secondary duty, teachers' duty to attend other jobs, evaluation of papers, attend students' camps, that is secondary duty. Similarly, collection of checks, maintenance of safe deposit lockers, collection of purchase of assets, these are secondary duties of the bank. So sanctioning one, if the duty is sanctioning one, so duty is created by law. If the duty is created by either by way of decree or order or injunction, and it may be the liability is created out of decree or order or injunction of the court or writ issued by the Apex High Court or Supreme Court, and these are the sanctioning. So suppose any duty is created by state under certain special circumstances. For example, during the period of COVID pandemic, whatever duties are imposed by the state are strictly adhered to by the people, otherwise they will be put to liability. These are the various things with reference to meaning and definition of this is meaning and definition of liability. Now, kinds of liability. One civil liability, one is civil liability or remedial liability. Civil liability means the liability that is created by civil court. The liability created by order of the civil court or decree of the civil court is called civil liability. So civil liability is enforcement of the right of the person against the defendant in civil proceeding. In other words, civil liability is the enforcement of plaintiff's right against defendant through order of the court or decree of the civil court, the court in civil proceeding. That is the civil liability. That is civil liability. So this is also known as remedial liability. This is also known as remedial liability. Suppose when a person suffers injury against private wrong, the aggrieved party can file a case in civil court for breach of a contract, or breach of contract under promissory note, or contract of sale, or any other issues. If he approaches the court, if one spouse, husband or wife, approaches court for remedy, either for restitution of conjugal rights or maintenance or dissolution of marriage by judicial separation or nullity of marriage, annulment of marriage, and whatever it may be, if the plaintiff or petitioner approaches civil court for remedy, the civil court will impose obligation. That obligation imposed by the civil court on the opposite party, that is defendant or respondent, is called civil liability. That is called civil liability. Though this is the purpose of civil proceedings is to give relief or remedy. Give relief or remedy. The relief or remedy is in the form of specific performance of the contract. Specific performance of the contract, because A and B enter into a contract of sale. A must sell the property, B must purchase the property. If A files, B can seller fails to sell, purchaser can sue. Purchaser fails to pay, seller can sue. That is what is called. If specific performance means the person who failed to sell will be asked to sell it. If the purchaser fails to pay, he will be asked to. That is what is called specific performance. Specific restitution of property. Restitution of property means whatever property the aggrieved lost, the property is to be substituted or restituted by the wrongdoer. Because A spoiled the crop of A's animals, A's cattle nibbled the crop of B, and B files a case against A for restitution of property. A should purchase a new crop and give it. That is what is called restitution of property. Similarly, some house of B's house spoiled by, damaged by A's cattle or A's animal or A's vehicle. So B can file a case against A for restitution of property, means reconstruction or damages, compensation, or there are injunction. The aggrieved may ask the court for injunction. It may be by way of injunction. Suppose the neighboring landholder is releasing water, and that releasing water is spoiling the plaintiff's crop. He can break court for injunction, that directing the neighbor not to release the water. For to do an act, injunction can be changed. Not to do an act, injunction can be positive injunction, negative injunction. In temporary injunction, permanent injunction will be there. So this type of injunction is order is given by lower courts. Order of writs is given by writs are given by higher court, like High Court and Supreme Court. The order to do an act or not to do an act is injunction in lower court level. An order to do and not to do, or to question the authority or compel the authority to do a particular act, is given by High Courts and Supreme Court by way of 5 kinds of writs. This is the position with reference to this thing. So next one is the theory of remedial liability. Remedial liability, in olden days, there are two theories: ibi jus, ibi remedium, ibi remedia, ibi jus. In olden days, there was ibi remedia, ibi jus, means if remedy is available, right was recognized. Remedy is available, right was recognized. This refers to Salmon's theory. If you refer my lecture on law of tort refers to Winfield theory, law of torts refer to Salmon's theory. So according to Salmon's theory, ibi remedia, ibi jus, if remedy is available, right was recognized. So that was the old theory. So ubi remedia, EB just means if A committed wrong, B suffered injury. If for that injury suffered by aggrieved party, if remedy is available, remedy is given. If remedy is not available, new remedy should be given. So that is, if remedy is available, remedy is given. If remedy is not readily available, the court should create new remedy and should give. That is Winfield theory, Winfield concept. So now the theory, ultimate basic foundation of this remedial theory is ubi just ibi remedium. Suppose A committed wrong, B suffered injury. If that injury contains the features of tort, for tortuous liability, A is liable. If it contains breach of contract, for that breach of contract, A should be made liable. For whatever it may be, A should be made liable, but B should be. If remedies are available, remedies were given olden days. If remedy is not there, new remedy is to be created. Accordingly, following the Winfield theory, so many remedies, new torts were created by the courts of England called common law courts, and the number of trades were increased. This what is law of tort, what is law of torts. If you refer my lecture, you can have good idea about this. Ubi remedia, ubi just, if remedy is there, right was recognized. Ubi remedia, ubi just, ubi remedia mean if right is there, remedy must be given, is the latest thing. So these are the oldest. This powers are conferred. The courts are in common law courts are having discretionary power to create new laws. But here the courts in India today are given independent jurisdiction, discretionary jurisdiction, and various principles. CPC provisions are there. Section 148 to 153B and so 226 and 227 High Court. Article 226 and 227 High Courts are having discretionary power. Article 32 and 136 the Supreme Court is having discretionary power to give any judgment of its choice without following what is there in law. Legislation, custom, precedent, or anything they can give. So now coming to the next theory. So there are exceptions. So there are some exceptions. So this remedy is not available in certain cases. Imperfect obligation. Perfect obligation means enforceable. Imperfect obligations not enforceable. Suppose if debt, if in a debt, a promissory note, in a promissory note is valid for 3 years. If suit is filed within 3 years, the creditor will get money from the debtor. If the suit is filed after 3 years, the creditor cannot recover the money from debtor. They cannot recover the from her. For everything, limitation period is there. If the suit is filed within limitation period, the remedy will be given. If the suit is not filed within the limited period, for everything, for filing a suit against matrimonial remedies and dissolution of marriage, whatever it may be, there will be limitation periods will be there. How we have to apply for admission into law or any other course or any job. There is a prescribed limitation period is there. Limitation period is there for filing suits. If it is filed beyond the prescribed period or limitation period, it is not available. So remedy is not available in this. Unenforceable duties. Certain duties are not enforceable. Moral duties are there. Suppose son has a duty, legal duty to feed his wife, children, parents, children. He has no duty to feed his brothers. So his duty to feed brothers and other relatives, friends is moral duty. Suppose though he is rich, his friend or brother or distant relative is poor, he doesn't pay, that is not. That aggrieved party who is poor cannot file against a rich man. He has a lot of money, he is my brother, he cannot say. That is called moral duty. If brother gives anything to brother, it is only moral ground. If one gives anything to friend, it is only moral ground. So moral duties are not enforceable. So impossibility of performance. So section 56 of Indian Contract Act 1872 speaks about impossibility. Law will not compel anybody to do what is impossible. Doctor, I will give you 1 crore if you give life to my dead child. That is impossible. I will give you 1 crore if you get if you can walk 100 kilometers in 3 hours, that is impossible. So any act should not be, an act should be, possibility of performance is one of the essential element. Impossibility of performance is renders the contract void. So suppose this is the position: giving life to dead child, doing agreement for impossible acts are void. So these are the exceptions to this case. Next one is criminal liability. Criminal liability means if wrongdoer commits wrong, it against society as a whole, public at large, or state against state, that is public wrong. That public wrong is called crime. That crime is called offense. The word offense is used in IPC, CRPC, and all special legislations of the criminal law. This offense. So offense, what is this offense? The purpose of offense is to give punishment. So here, what is criminal liability? The criminal liability is the liability to be punished in a criminal proceeding. Like criminal liability, the purpose of criminal liability is that the liability, the person who has committed a criminal wrong, crime or offense must be punished. The object of criminal liability is to give punishment to the wrongdoer. This is due to several reasons. There are 5 kinds of punishment. There are different kinds of punishments and theories. I gave very big lecture in criminal law, theories and kinds of punishment. So old punishments I have given, new punishments I have given. New punishments we have fine, simple imprisonment, rigorous imprisonment, life imprisonment, death sentence. So these are the punishment. So there are the theory of criminal liability. There are 5 categories of 5 kinds of punishment, 5 theories of punishment, namely deterrent theory. Deterrent theory means by giving punishment it is a warning. Suppose if the person who committed murder is sentenced to life imprisonment or death sentence. That is why nobody would like to kill anybody, because that man committed somebody, he is in prison. Suppose Rajiv Gandhi assassination case, the convicts are in prison for the last 30 years. That is why nobody can venture to kill any top leaders, national leaders. So they are in prison for the last 30 years. It is a fear. Suppose if a wrongdoer in criminal law is punished, the surrounding people will have fear. To create fear in the surrounding people that if we do that crime, we also will be punished like that. That is deterrent theory. Next, second one is retributive theory. Eye for eye, head for head. It is old law. Eye for eye. Suppose if you break my head, I will break your head. If I amputate my limb, I will amputate your limb. If A kills B, B's legal here will kill A. That is head for head, eye for eye, nose for nose. That is the punishment. Next, preventive theory. Preventive theory means if one person A committed one wrong, he should not commit the same wrong again and again. In order to, this theory is called theory of disablement. Suppose if he is freely allowed in the society, he will commit one more theft, he will commit one more robbery, he will commit one more murder. So he is put in jail. He cannot have freedom, he cannot do any more crime. That is what is called preventive theory or theory of disablement. Next, reformative theory. When we are putting the people in prison, instead of giving them food without any work, we have to reform them. No criminal is not a born criminal. Everybody is not a criminal by birth. By surroundings only anybody may become criminal. So let us convert them into good people. And in prison, so many trainings were given. They are reformed. Some work is given. Some jobs are given. Some creative works are given. There are so many things were adapted. So many things were introduced to bring about change in the mind, change in the discipline and mannerism of the prisoner, so that though they were prisoners in the beginning, culprits, they will become a good people. If the behavior is good, they will be released well in advance for the good behavior. They will be awarded some marks. Depending upon the scoring of the marks, they will be released earlier into society. So this is what is called reformative theory. This is that is the reason why today presents are we are like a small village with big compound wall, electrified compound wall. They can in the present they can move like they move within a village. Within a village, they are open. They can move everywhere. Within they can do various works. In night time only they will be put in cells. So this is what is called reformative theory. Reformative theory. Next one is reformative theory. Next one is expiatory theory. Expiatory theory means mental recovery. Suppose I have killed him with my own hands. I want to cut my hands. So I killed him. I have no right to live. I also must die. That is what is called realization and agony, mental agony mental agony, suffering of mental agony for having committed a particular act, a particular crime. I have killed him with my own eyes, but I have own hand. I have no right to live. I also would wish to lie. So that is what's called expiatory theory. These are the various theories for criminal liability. Criminal liability kinds of punishments are there. Today there were old variety of punishments were flogging, branding, stoning by death like this, and modern punishments, so 5 to simple imprisonment, rigorous imprisonment, life imprisonment, sometimes for 14 years, sometimes 20 years, sometimes till death, like Rajiv Ashashna's case, and these are the things. Like ultimately death sentence is there. Death sentence also is subject to certain rules and regulations, minor if any. That is what is called an Nirbhaya case is best example on this. So these are the this is with reference to criminal liability and theory of penal liability. So civil liability I said, the theory of remedial liability I completed, criminal liability I have completed, and the theory of penal liability also has been completed. Next one is joint, several and constructive liability. I have already told you. Joint and several liability is in civil litigation. Joint and constructive liability is in criminal litigation. So suppose 3 persons jointly take money, 3 of them will have to pay equally. If 3 are should, one alone should pay the entire 3 lakhs. He can recover money, respective money, by filing a case from 2 joint this thing. It may be in law of torts, law of contracts, liability is joint and several. In criminal law, the liability is joint and constructive, because if punishment is given, life imprisonment is given to all. Death sentence is given to all. So this is the position. That is joint. Vicarious liability I have told you. Vicarious liability means one person commits wrong, other person is put to liability. That liability is called vicarious liability. It is based on 2 principles: qui facit ferilium, facit farsi, and respondent superior. He who does an act to another deemed in law, do it himself. If you have to do your own work. If you get it done by somebody, it is deemed to have been done by you. You are responsible for that. If you have lorry, you must drive it. If you engage driver, if he commits any accident, it is deemed that accident is deemed to have been committed by that. You must be liable. That is qui facit perilium, facit farsi. Respondent superior. If wrong is there, there are 2 persons. One is weaker, other is stronger. Put liability on stronger so that he can meet liability. Agreed will get relief. But if you put liability on weaker, that is lorry driver, he can't do anything. That is respondent superior. These examples are master, servant, employed, independent contractor, principal, agent, firm, directors, and all these things. Vicarious liability of state. State government, earlier state was immune, state was exempted from liability. That was called sovereign immunity. But in course of time, governmental transactions have been increased. In England, Crown Proceedings Act 1947 was passed, but in India, there is no any act imposing liability on the state. Article 300, Clause 1 and 2 make provision for liability of the tortuous liability of the state. Article 298 and 299, Article 298 and 299 of Indian Constitution make provision for contractual liability of the government, but there is no any legislation prescribing government liability. Even today, we have no any law or legislation prescribing liability of the state or government, and liability of state or government on state liability or government liability or and sovereign immunity. I have given very big lecture in Law of Torts, dear friend. You please look into it, refer it. You can have very good idea. So vicarious liability of state are next. Vicarious liability. Vicarious liability in criminal law. Vicarious liability in criminal law. Vicarious liability in criminal law in the sense I told you. So vicarious liability is unknown to criminal law. Suppose a tailoring servant has steals the suit. Tailor is not liable. Tailor is not liable. Suppose I am the owner. And my owner of the shop. And if anybody commits theft of the articles of customer, I am not liable, but the owner will have civil liability. Criminal liability is not there. Suppose a lorry driver commits accident, kills two persons. The owner of the lorry is liable to pay compensation to the deceased persons, legal heirs, nominees, but he is not liable for imprisonment. The driver will have liability. So vicarious liability, master liable means the master alone is liable. Master liable doesn't mean that servant is not liable. Servant also is liable, but the servant will have criminal liability. Civil liability servant cannot afford. That is why master will meet it. So the master may recover from servant also in future, is left to their relationship. So this is vicarious liability, criminal law. Suppose in vicarious liability in Srinivas Mal's case, goods were adulterated by servant without the knowledge or consent of the master. So master is not liable. Rahul Hariprasad Rao case, the supply of petrol was misused by a servant with the consent of the master. If master consent is there, master is liable like an abettor. Master is less than master is liable. So vicarious liability, in vicarious liability, master is liable if the wrong is committed with his consent and knowledge. If crime is not committed, if a crime is committed without the consent of master, the master is not liable. That is Srinivas Mal case versus state. The Rahul Hariprasad Rao case means petrol supply was done without. For these things, if you refer the doctrine of mens rea, in criminal cases, you can have full knowledge. I explained this topic, doctrine of mens rea, in criminal law lecture, elements of crime. And the next one is criminal abatement. Abatement is there. Abatement means if master engages, suppose A engages B to kill C, and C is killed. Then if B is caught, he will tell, as per the instructions of A, I have done it. Then A and B are equally liable. That is called abatement. So whatever punishment is given to principal wrongdoer, same punishment is given to abettor also. This abatement I have given very big lecture. You can see section 107 to 120 of Indian Penal Code lay down various provisions relating to this. Similarly, public nuisance also I explained in Law of Torts. Suppose the nuisance causes inconvenience to public as a whole, that is crime. When drainage of my house causes inconvenience to my neighbor, it is private nuisance. My neighbor alone can file a case. My drainage of my house extends towards the road. All road users, that is public nuisance. It is crime under section 268 of Indian Penal Code, and public nuisance is punishable under section 269 to 290 of the Indian Penal Code. Next, occupiers liability for rights and unlawful assembly. The owner of the land is also liable. He cannot say that vicarious liability to unknown to criminal law. So, vicarious liability is unknown to criminal law mean owner is liable. Exceptions mean owner also will be liable. For abetment, if the crime is committed with consent of master, master is liable. If it is public nuisance, master is liable. If it is occupiers liability, master is liable. Occupiers liability under section 154 to 156 of the Indian Penal Code. Next one is strict liability. I told you, liability irrespective of negligence coined by Justice Blackburn in Rallens versus Fletcher is strict liability. In strict liability, whether wrongdoer is liable or not is not seen. This type of strict liability was coined by Justice Blackburn in Rallens versus Fletcher in the year 1860. So here the employer and independent contracts liability. So the employer tells that I employed independent contractor, I am not liable. No. Till now you are not liable. Though you don't have, you are not negligent. You engaged a qualified engineer, but still it is liable. Secutor, telenum, non-lades. Everyone must so use his own not to damage others. All these aspects I have given. So prior to this strict liability, if defendant has negligence, defendant was liable. If defendant has no negligence, defendant is not liable. For example, suppose I am editor of a daily. I received some defamatory information. I should check whether it is true or not. Suppose I have received some defamatory statement about scam indulged by some politician. Whether it is right or wrong, I should check and publish it for public use. Without inquiring, without taking any precautions, if I negligently publish it, I will be liable. So, if negligence is there, a person is liable for defamation. If negligence is there, a person is liable for any wrong. Whether a defendant is negligent or not negligent, whether you are negligent, you are liable. Though you are not negligent, you are liable. Liability irrespective of negligence is strict liability. This strict liability was created by Justice Blackburn in England in Rallens versus Fletcher in the year 1860. Strict liability means liability imposed on defendant irrespective of negligence on the part. However, there are some grounds. 5 defenses are given to defendant to escape from the liability, namely act of God, malicious act of stranger, plaintiff's own fault, common benefit, statutory authority. If the defendant can prove any one of the defenses, defendant is not liable. So in strict liability, there is a chance to defendant to escape from the liability. That liability, though he is negligent, liability irrespective of negligence, that is strict liability. But he has a chance to escape liability. So the strict liability minus defenses. There are no defenses. Liability irrespective of negligence without defenses is absolute liability. This absolute liability was coined by P.N. Bhagavati in M.C. Mehta vs. Union of India in the year 1986 in oleum gas leak case, that is M.C. Mehta vs. Union of India in 1986. Then Chief Justice P.N. Bhagavati coined this principle of absolute liability. I explained in detail in Law of Torts the principle of absolute liability. And last one is no fault liability. No fault liability, a contributor negligence in negligence chapter tells that if the wrongdoer is 100% liable, he should pay 100% compensation. Suppose a wrongdoer commits accident, wrongdoer is 100% liable by drinking in intoxicated state or talking to cell phone and rash driving, whatever it may be. Then the owner of the vehicle is 100% liable. If compensation payable to victim, deceased person, is 5 lakh, he should pay 5 lakhs. Suppose the wrongdoer is driving the vehicle carefully, but the deceased with seeing talking in cell phone, looking this and that without observing approaching cone, suddenly crosses the road and died. He is 50% liable. For such cases, 50-50. Then 5 lakhs 50-50 means 2.5 lakhs is liable. Suppose aggrieved party is 20% liable, only 1 lakh is paid, 80% not paid. This is if 100% paid, 100% aggrieved liable, there was no liability. Oriental Fire and General Insurance Company in 1980 case is there, but thereafter, after 1980, when a person may die, the deceased might be 100% responsible, negligent, but still the overseas welfare state, when a person died with 100% negligence, his near and dear next kith and kin must be protected financially. For that purpose, no fault liability was created in order to give, even though the aggrieved party deceased 100% liable, he fell on back wear intentionally. Still, some liability was created. For state government will give some finance something, central government will finance something, insurance company will finance something. That no fault liability was created. This type of no fault liability was created in the year was created by making amendment to after 1980 Motor Vehicles Act 1939 was amended. Under that Amendment Act, Chapter 7A was created. That Chapter 7A contains Section 92A, and even though the deceased or aggrieved is 100% liable, if he dies, 15,000 was paid. If he is totally permanently disabled, unable to do any work, fit for nothing, 7,500 was created. Subsequently, the Motor Vehicles Act was recodified in the year 1988, and this no fault that came into force from 1st July 1989. This under this Motor Vehicle Act, this is most of the sections are available, even valid today. At section 140 to 144 deal with no fault liability. Under the Motor Vehicle Act 1988, for death 50,000 compensation, for disablement 25,000 compensation. This Motor Vehicle Act 1988 was amended in the year 2019. This came into force from 1st September 2020. The Motor Vehicle Amendment Act was passed, and it came into force from 1st September 2020. And according to that, the compensation for death was 2 lakh. Compensation